Good to go? All right. Well, welcome to the public meeting for the water rights adjudication for the Lehi Subdivision. If you can find a seat, grab it. If you can't, if you want to stand against the wall, that's just fine too. First of all, introduce myself. I'm Blake Bingham. I'm the Assistant State Engineer. I work for the Division of Water Rights, and I am responsible for the adjudication program throughout the state of Utah. And we'll get into more of the details as to what that means and why you've all been called out here tonight or received a summons and those types of things. But first of all, some kind of rules of engagement here is that if at any time tonight that you're satisfied, your curiosity's been satisfied, feel free to step up and walk out. You won't hurt my feel bads. We all got things to do, so if you have something more pressing to get on to, feel free to step up and leave, no worries. Plus, we are recording it and we're streaming this live on the internet, but it'll be available to watch as well on our website, on our YouTube channel. So if you have some questions or you want to revisit something, you can go back to this slide. And the slide presentation will also be on our website as well. Questions. If you have questions that kind of apply to the broad topic at hand, I'm happy to answer those throughout the entire presentation tonight. If it's something that's more specific to your own situation, I would just ask that maybe you hold off and I can answer them at the conclusion of the meeting so we don't waste everyone's time. We also have some staff that are out in the hallways that can answer questions if you want to step overview of what it is, what it means. We'll talk about what a proposed determination is. That's a term that you'll hear often tonight and ultimately is kind of the crux of this whole process. We'll talk about some significant issues and anticipated timeline and then some questions. If you're tuning in at home via the internet, if you have questions, feel free to email them to that that email address there at the bottom in blue. At the conclusion of the presentation, I will do my best to answer those questions. If you off in time and the presentation. When we talk about water rights adjudications, I often like to kind of go back to basics, maybe Water Rights 101, and talk about what is a water right in the first place, because I think there's some confusion as to what a water right is, how it relates to maybe shares in an irrigation company or a water company, and those types of things. So bear with me if you already know all of this stuff. We're going to cover it for those who don't, all right? We're going to break it down Barney style and then build from there so everyone's water right experts by the end of this presentation. All right, so a water right is really just a right to divert water from its natural source and place it to beneficial use. It typically has a few different defining characteristics. You have the defined nature of use, and that's kind of what it's being used for, whether it's being used for irrigation or whether it's being used for stock watering or domestic purposes. As a priority date, where in line that water right gets satisfied. So in Utah, we have very little water. First in time is first in right. So if you have a senior priority, that means you get your water before someone with a junior priority. At least in theory, that's how it's supposed to work. There's a defined quantity of water. We typically measure water via either a CFS flow rate or by an acre-foot volume, an annual acre-foot volume. CFS meaning cubic feet per second. Water rights also have specified points of diversion, and that's just kind of a fancy word for where the water is coming out of the source, all right? So if you have a head gate on a stream, that's the point of diversion. If you have a well, that's the point of diversion. If you have a spring box, that's the point of diversion, okay? So that's just the term used to describe all those different types of ways of diverting water. Then there's a specified place of beneficial use, and that's just as it sounds. It's where the water is being used physically. You know, we identify that using the public land survey system. You know, what section or what quarter it's in within the section and township and range. Usually when we send out these summons, and I need to backtrack a little bit. So you're not obligated to be here. I know when you receive that mail, you receive the summons in there, and it says you are hereby summoned to appear and defend your water rights. You don't have to be at this meeting. That summons is part of the statutory process. I'll talk a little bit about why it's necessary here in a bit, but I apologize. It's just what we are obligated to do to make sure that this is binding and we follow the law. So I know it's scary to receive that. We try to dial it down. Usually when people receive that summons, the first thing they want to do is give us a call and ask us, well, how do I know if I have a water right? And so typically what we tell them is if you have something that looks like a well or you have a head gate on your property, those are typical evidence that you may have a water right, or even like a spring box, okay? That doesn't mean you do have a water right, but that's pretty good evidence that you may, all right? What a water right is not. It's not a share in an irrigation company, and that's probably one of the biggest confusing parts of this, okay? So shares are, and maybe there's people in here who obviously know what a share is because you have share in like Lehi Irrigation or some other irrigation company. But how a share works is the water right, the actual right to divert the water is owned by the company or the entity. And then they have those rights and then they distribute shares. They distribute water to people or shareholders based on their respective shares in the company, okay? So although you may have a share, we're really talking about water rights. That's what the division is really concerned about. Shares are really kind of an interaction between the company and the shareholder, and the division of water rights doesn't really get in between that interaction. So you might have some communication there. Does that mean if you're a shareholder that you really can just ignore this and drive on? Potentially. We prefer if shareholders stay engaged to make sure that their company is acting on their behalf in the right way, and that they're making sure that the company's filing their claim and asserting their beneficial uses. Okay, and I know there's a few people in here who have seen this presentation multiple times, so I'm just going to apologize. There's no new material, jokes are the same, but for those of you who haven't, to understand really what the adjudication process is, it's important to have kind of a historical context. So you understand why we are here doing this today, and it'll help demystify the process, maybe allay some of the concerns that this is a grab by the state of Utah or by a municipality or some other company to grab your water rights. So bear with me. We're going to do a quick history lesson. I'll try to make it as entertaining as possible, but it'll provide a little bit of insight as to why we're doing this, okay? So we are all familiar with the story of Brigham Young entering the valley on July 23rd, and, you know, identifying this as the place. You know, right away they started diverting the waters of City Creek, and then they built their shopping mall on top of it in short order. But they started diverting the waters of City Creek right away in order to soften up the ground and kind of plant a late season crop, all right? Not long after that, Brigham Young, who was kind of the de facto ruler, because it was kind of a power vacuum, right? There was really Mexico at the time. So Brigham Young made this statement. He said, "There shall be no private ownership of the streams that come out of the canyons. These belong to the people, all of the people." And so in some sense, that's one of the main tenets of water rights today, that the water is really not owned by people. Let me back. It's not owned by the state. It's owned by the people as a natural resource, and that's one of the basic tenets of water rights. It's a natural resource that the state helps to effectively distribute, but it's owned by all of us, right? Well, between 1847 and 1850, what we now know as Utah started off as a part of Mexico, and then it became this quasi-state, ecclesiastical state of Deseret, and then eventually turned into the territory of Utah. However, just because it went through those transitions, the government itself remained church-centric. When I say church, I'm going to refer to the Church of Jesus Christ of Latter-day Saints, so bear with me. As a result of that, diversions of the waters from the streams were done on a community basis to meet the immediate needs of the settlers. Brigham Young would send settlers north and south all over the place, right? And they would start digging ditches and start diverting the waters to plant their crops, so that because they subsisted on the crops that they raised. As a result of this kind of evolution, the people who built the first ditches, dug the ditches, diverted the water first, they claimed the first priority of the water, right? They said, well, we did all the work, so we get the water first. And then you would have subsequent settlers who would come in, and being good Mormon, people, they said, well, we don't want to completely deprive you of water, but you get the water after we get the water. So this concept of priority kind of began to evolve. You had primary rights, then you had secondary rights. And this is actually a concept that started in Utah and was exported to other states throughout the West, actually. It's kind of interesting. Also, conflicts were resolved by ecclesiastical channels. You had the bishops that would settle disputes among different members of their wards, and if they didn't like what the bishop had to say, they'd take it to the stake high council, and the stake high council kind of act as an appellate court and overrule the bishop or side with them, okay? And that's just how conflicts were settled, because there was no other type of framework for government. Well, as we transitioned into the territorial era, in 1852, the first territorial legislative assembly attempted to kind of wrangle this power out of the church, the LDS Church's hands, and what they just said, well, instead of bishops and stake presidents really administering water, what we're going to do is we're going to give it to the courts, the county courts, and they're going to be responsible for timber and water rights and all these other things. But at the time, the county courts, those were elected positions. To be a judge at the county court, you got elected by your fellow citizens, right? So you can imagine the people that were being elected to those positions, right? It was the bishops and the stake presidents. So there wasn't a whole lot of difference between the old ecclesiastical channels and the bishop and these courts. And for the most part, streams continue to be diverted without any credence given to the respective court. Well, in 1877, the Desert Land Act was passed by Congress, and really it was intended to help homestead the West. They wanted to promote people to move west and homestead this arid part of the United States. Some of the consequences of that act is that it severed title between land and water. So back east, you had this concept of riparian rights, where if you lived adjacent to a stream, you had an automatic right because you lived adjacent to that stream. Well, in Utah and the area, don't have that many streams, so you've got to be able to divert water and apply it elsewhere. And the Mormon pioneers were already doing this. This simply recognized that officially, and also delegated the authority to the respective states or territories to administer water rights. And some of us might think, well, that's a foregone conclusion, that makes sense. But keep in mind that the federal government was still responsible for land patents, right? Land patents. They still administered the government land office. So you couldn't own any land without going through them. But this said, well, if you wanted water, you had to go to the state or the territory. There were some failures in this, obviously. They tried to fix it. They wanted to, at some point, they wrote this county selectmen who would go in and say, and kind of act as mediators and give certificates. But it wasn't really followed, and it really only followed in maybe Salt Lake County. Everywhere else throughout the state, they were kind of doing whatever they wanted. As a result of this, confusion continued. In spite of the best efforts of the legislature or even the church. And the church continued to administer and decree water rights. An example I often cite is the High Council decision that divided the Spanish Fork River. And believe it or not, that's still how that river is divided, is among those irrigation companies that the High Council decided to administer back in 1879. There's been some subsequent changes to it, but for the most part, that's how it's administered. Well, in 1896, Utah became a state. There was a lot of fear as they drafted their first constitution and their first set of laws that the newly formed legislature would confiscate all the water rights. As you can imagine, that caused a lot of angst amongst the farmers and those who had relied on that water to just have the state say, nope, you don't own it anymore. It's now the state's and we'll figure it out. And so as a result of that controversy, they decided to just punt. And all they did is they said, well, we're not going to figure out the law right now, but what we'll do is we'll write one provision into the Utah State Constitution. And in essence, Article 17 still says to this day, All existing rights to the use of any of the waters in this state for any useful or beneficial purposes are hereby recognized and confirmed. So what they were, in essence, recognizing is if you were operating a water right, or you had a water right and you were using it, you were good to go. You were kind of grandfathered in, right? You had this diligence claim to this water. Well, in 1897, the state legislature wanted to find out what type of resources there were in Utah. You know, what were the streams like? How much water was really actually flowing down them? So they created the office of the state engineer, and that's kind of the traditional or historical name of the Division of Water Rights. So the executive director of the Division of Water Rights is the state engineer. Well, they created this office to just kind of figure out how to build dams and measure flows, but they still relied on the system of appropriating new rights based on the old system of going and actually kind of not pounding your stake into the river by the point of diversion, then going filing a claim by the county recorder or the post office. So it's kind of old school, and it was largely ignored. In 1902, the United States Reclamation Service was organized. We know them today as the Bureau of Reclamation, and they kind of put it to the states this way. They kind of said, hey, and for those of you who don't know, the Bureau of Reclamation were responsible for building massive irrigation projects or reservoirs throughout the West in order to reclaim. That's where they get their name, reclaim the arid West. Well, they kind of came in and they said, well, we're not building anything in your state until we know we have a water rights to satisfy to actually fill this reservoir. And so until you guys can get your stuff together and come up with some laws and come up for some ways of figuring out what water rights are already appropriated, we're not going to build anything in your state. So it's no coincidence that 1 year later, the state legislature enacted the first comprehensive water law that called for recording of all existing rights, remembered all those grandfathered rights, as well as appropriating new rights. Unfortunately, the legislature failed to provide any funding for adjudicating those existing rights. So they built the framework, then didn't really provide any funding. And really, there wasn't a mechanism. So they pretty much just said, all right, the courts are responsible for adjudicating water rights. We'll just let them deal with it. Well, if you're a judge, that just doesn't work because you're not going to go out and look for water rights. You wait for cases to come to you, and then you make decisions between competing parties, right? And so it just never worked. Well, in 1919, they finally figured out that was just never going to work. So they provided the machinery, the modern-day machinery, for the state engineer to conduct a proposed determination of water rights. And that's really kind of what we still do today. The state engineer goes into an area, takes record of all the water rights, gets all these old diligence claims or all these old grandfathered rights onto the record, makes a determination, and then brings that to the court and says, here's our recommendation to you, judge, and the judge makes a ruling on it. Now, people have an opportunity, as we'll describe here, to say, well, the state engineer screwed up or this or that. But that's kind of the overall machinery that we have today. So I'll say in 1903, that first comprehensive water law was only for surface waters, right? You could punch a well anywhere you wanted without a water right, even beyond 1903. Well, in 1935, they finally figured out that, hey, surface water and groundwater, it's all the same water. It's hydrologically connected. So you probably ought to have a water right to have a well. So prior to 1935, you could drill a well without having a water right. After 1935, you had to appropriate a water right to get to have someone come out and drill a well. And so same thing for surface waters, 1903. Prior to 1903, you could divert surface waters. After 1903, you needed a water right to do that. Okay, so prior to the enactment of that first comprehensive water law, water rights kind of fell into a few different categories, all right? First, you had those that were simply decreed by ecclesiastical fiat, right? The bishop or the stake president said, you owe this, you have this much water, you have this much water, or the stake high council, or whatever. You had those claims that were filed for record at the county recorder. You had rights that were decreed by a court. Often what would happen is people who on a same stream or same ditch would fight, and they take their case to the court, and the court would make a decree saying, all right, between these two parties, this is how your water rights are settled. The problem with that is there's probably several other parties along that ditch that aren't a part of that suit, haven't been joined, haven't been summoned, and so the ruling wasn't really effective for anyone else except for the parties that had come before the judge at the time. You had kind of contracts among different parties that just said, hey, we have this water, you have that water, let's make an exchange. And there's quite a few of these in the Salt Lake Valley. And these were just informal or formal contracts, but were never really recorded on the water rights anywhere. And then you had those claims that were never manifested on any type of record whatsoever. These are maybe that you had someone up who just never felt like he needed to file a claim, or because he had been using water prior to 1903, there was no issue, no one harassed him about it, so he just continued to do that. And that was perfectly acceptable, perfectly within his right, because he had one of those grandfathered rights. And so you have these claims that aren't listed anywhere. They're not filed at the county, they're not filed anywhere, they're just pre-statutory in nature and unknown. Well, as a result of that, there's a couple of issues. First of all, there was no public record of these water rights. There certainly wasn't a consolidated public record where you could go one place and find out about a water right in St. George, They just weren't anywhere. And whatever records there were really difficult to find. Since there were no records, over-appropriation was rampant. It's very common for judges to decree much more water than would ever flow in a specific creek, and so obviously that continued to be controversial. Often rights weren't defined until they came into controversy, so you just kind of had someone, well, I'm just using this many miner's inches of water. And anyone here know what a miner's inch is? Maybe you've heard that term, but it just used to be a little hole that they just poked in, and that's their way to measure water. So they really had no way to figure that out, and until they brought it before either the ecclesiastical courts or the actual courts. As a result of this, so the state engineer recognized this issue, and prior to this legislature adopting this comprehensive water law in 1903, he made this observation. He said, the definition of existing rights, talking about some of those pre-statutory rights, those grandfathered rights, appears to be of first importance. This is not only necessary to pacify present contention, but to prevent future conflicts and encourage further progress. There can be no safe basis for future work before existing rights are known and made of public record. So that was 1902, right? And the whole theory was, what we're going to do is we're going to go find out all these grandfathered rights. We're going to bring them onto the record. And then once we know what we have, then we'll start appropriating new rights. Well, people got tired of waiting because nothing happened until the 1920s. And so they said, well, okay, this is just untenable. People are complaining. We've got to start appropriating. So you have these two separate tracks. You have the adjudication trying to figure out old grandfathered rights, and you have the system of appropriation creating new rights, okay? And so the theory was, well, we're going to adjudicate first, then appropriate. That fell apart. So today, we do both. So what is a general stream adjudication? Well, as I've kind of hinted, and as the name implies, adjudication, it's a court action. It's in the state district court. So the adjudication we're talking about tonight is actually the Utah Lake Jordan River General Adjudication, and the court that presides over is the Third District Court. It binds all water users and the state engineer the reaches of the adjudication. That's the title of statute it's governed by, if you ever want to read something to put you to sleep. The first general stream adjudications took place in the 1920s. You'll remember it wasn't until 1919 that the legislature figured out that the courts aren't going to figure out water rights on their own, so they gave them the proposed determination concept. So in the 1920s, they started implementing that. And the first basins to be adjudicated were like the Weber River Basin, the Sevier River Basin, the Virgin River Basin. So you look at this map up here, and you see lots of different colored items. So when I talk about the Weber River Basin, I'm talking about this teal blotch up there. The Sevier is this blue looking one, and then the Virgin River is down here. The adjudication that this subdivision is a part of, as I said before, is the Utah Lake Jordan River General Adjudication. It's that big purple blotch, okay? And it was actually initiated back in 1936 as a result of a court case that Salt Lake City initiated against a bunch of water users along the Jordan River. There was a big drought. People were stealing water out of the Jordan River. They didn't have a right to it, so Salt Lake City sued like 2,000 people along the Jordan River. They took it to court, and the court said, hey, this is too comprehensive for us to settle. It needs to be, and it involves other tributary water sources. We're going to turn this into a general adjudication, and that's when the Utah Lake Jordan River General Adjudication was born. All right, so why do we conduct general adjudications? First of all, we want to bring all claims onto the permanent record. Remember this guy, he's diverting water prior to 1903, doesn't have a worry in the world. Well, we want him to come forth and bring his claim forward so we can have it on our record. And so we have diligence claims, and so you'll hear that term, diligence claim, and that's generally associated with surface waters that were being used prior to 1903. You also have these things called underground water claims, which are similar in concept, but it's for underground water that was used prior to 1935, okay? And then we have Federal Reserve water rights, and this has nothing to do with the Federal Reserve that prints money. This is a concept that grew out of a Supreme Court decision. We often call it the Winters Doctrine. And what happened is, around the turn of the century, the Fort Belknap Indian Reservation, the Indians there were trying to do their best to become domesticated and agricultural based, but they couldn't do that without some water. So they went to their equivalent of the state engineer in Montana and said, hey, we'd like to appropriate some water from the Milk River. And the state engineer kind of said, well, tough luck, Chuck. It's already over appropriated. There's no water for you because all the settlers have already appropriated it. Well, you can imagine that didn't sit well with the Native Americans at the time, so they took them to court. And the Supreme Court ruled that because Congress had reserved that Indian reservation and intended them to become an agricultural people, that there was an implied water right with that reservation. And the water right had the same priority date as the establishment of the reservation. So why does that matter to Utah? Well, obviously, Utah does have some Indian reservations in the state, but even more important is that this same concept has been applied by the courts to other types of federal reservations. And when you look at Utah, you can start to see the magnitude of this issue. We have National Park reservations, National Monument reservations. You have Forest Service reservations. So all of that Forest Service land has a potential water right associated with it. And you say, well, how much is that water? And we would say, we don't know because the federal government won't tell us. Hey, federal government, you're going to waive your federal sovereign immunity in the case of general water rights adjudications. So the problem before is you couldn't sue the federal government unless the federal government says, okay, you can sue me, right? It's kind of hard. You can't take them to court unless they give you permission to do that. Well, the McCarran Amendment says, hey, the federal government waives that ability for water in state court, all right? And so that forces the federal government to bring a recommendation to the court that, well, they claimed this much, but we don't think that's right. We believe it's this much, and then we fight it out in court. Or we negotiate beforehand to make sure it's fair. Another thing we want to do with the general adjudication is prevent a multiplicity of suits. We don't want people suing everyone else. We just want to do one big suit where everyone sues each other and get it over with, right? So that's kind of what this is. Okay, so here's typically the more controversial aspect of this. And this is usually where people start asking questions. And then once one person asks a question, then it's like the floodgates open up. So part of the Utah law, and really law throughout the western United States, is this concept of use it or lose it, all right? There's a limited amount of water in the state and in the West, but there's a more demand. The demand exceeds the amount of water, obviously. And so the state legislature back in 1903 said, well, hey, how can we prevent someone from monopolizing the water? And how can we also incentivize people to put it to beneficial use so it's being used? And they said, well, what we're going to do is if you haven't used your water in 7 years, it's subject to forfeiture. Meaning, if you don't put your water right and you use it for 7 years, the court can say you no longer have that right because someone else is using that water. And so that might strike someone as really unfair and controversial, and I empathize with that. But let me kind of put a different spin on it, and let's see if we can understand why that's the case and why that's important. That water doesn't magically disappear because you're not using it. It continues to go on down the river and is used by other people, okay? And so after years progress and time goes on, entire communities are developed based on this water that they've come to rely upon. So if you were to suddenly reappear 20 years later and say, hey, I'm going to start taking my 100 cubic feet per second again, suddenly these people who have become reliant on that water for the last 20 years are out of luck, right? Because they have a junior priority date to your priority date. And so that is the main overarching reason why we have this system, is to protect and to incentivize people to use their water and not hoard it or monopolize it and broker it and those types of things, okay? Lastly, we want, yes, sir?
What do you mean by broker it?
Well, it's full right to broker it. What I think I was intending to imply by that is to monopolize it and use it as kind of their, it's all right to sell water rights. You can sell water rights in and day out, right? God bless America, capitalism, all that good stuff. Capitalism pays taxes, taxes pay my salary. I have no problem with it. But as far as monopolizing, I'm more referring to the ability to monopolize water and sit on it and then force people to come to you and sell it that way. Did you have another question?
Yeah, so if you lease your water rights or whatever, that is a proper use of it.
Yes. So his question is for the benefit of the rest of the crowd. He had a follow-on question and comment that, hey, if you lease your water to someone else, that is an appropriate use, and absolutely, and that protects it from non-use and forfeiture and those types of issues. As long as the water is being used, you can lease it, you can sell it, you can do all those types of things. All right. Is there another hand? Sir?
You know, you keep taking away from the aquifer. You know, you get these other people in Salt Lake that want this water, you know, because it's maybe running down into Utah Lake. Somewhere along the line, you've seen down at Cedar City where the aquifer's been brought down with wells.
Mm-hmm.
You know, that water, if it can get back to the ground, it's just like a reservoir in there that we're drawing it down real bad with the growth and the things going on in the lake.
Yeah, so just for the benefit of everyone, he was expressing concern over the tendency for us to deplete the groundwater, right? We're pumping more than the groundwater is being replenished. The governor has mandated a state engineer to try to get it to a point of equilibrium where we're only using as much water as is being replenished. But you're right, the Salt Lake Valley, Utah Valley have been long over appropriated, and there have been a lot of wells. And I imagine there's probably a lot of people in this audience who have seen their own wells go drop, right? And they've had to dig them deeper and drop their pumps further, and it's a result of just increased use of that water. But yeah, that's very common. It's not unique to this part of the world, and you mentioned Cedar Valley and those other areas. But yeah, it's part of that deal. Hopefully, we're trying to get it back to equilibrium, but it's a long process. I mean, some of this water takes thousands of years to get from the mountains into the groundwater table. So it's not just a magic button saying stop pumping so much and it's going to suddenly reappear. So it's a complicated process. And again, from the state engineer's office, our objective is to make sure people are using their water rights within their water rights. And if you have a water right to pump the groundwater, that's all we are concerned about. As far as reaching equilibrium, that's kind of a different process, and the state engineer has some roles in that process, but I'm not going to get into that here. All right, so let's talk about the adjudication process. It's really kind of a three-phase process. This first phase, represented by these first 4 steps. Step number 4 is what we're doing tonight. We started off with the petition. In this case, the Utah Lake Jordan River was really started by a court case. So step number one was the court started the general adjudication. We sent notice. We published notice in the newspaper. We sent everyone summons. Everyone who was in that area received a summons and notice of this proceeding. And then we're having the public meeting. So let's talk about the next couple steps. And I'll dig into these next steps in subsequent slides. So if you don't understand, this is just kind of a thumbnail sketch of the entire process. So bear with me until I get past this slide. Then we'll dig into what the next requirements are and where we go from here. So after this meeting, in about a week or two, we're going to send notice to everyone to file a water user's claim if they are claiming a water right. Okay? If you're a water right owner of record, we'll send you what we have on our records to you for you to simply sign and return to us. If you are just a property owner and you don't know if you have a water right or not, maybe there's a well that's been there since 1920 and you never filed a claim on it, you'll get a blank claim form to fill it out. And we try to do our best. We encourage you to contact us and we'll help you fill it out. So, yes, sir?
We did this in 1988.
Say that again, sorry?
We did this in 1988.
That's a good point. So he
Doing it again.
yeah, so great. Hey, thanks for bringing that up. So he pointed out, this gentleman over here pointed out that, hey, a lot of us filed claims back in the 80s, right? Why are we doing this all over again? What's really happened is they failed to continue on with the process. Okay, wait till afterwards and I'll talk to you about it. So, yeah, we did. We sent people around and had them file claims. And matter of fact, we have a lot of water users claims already on our records. If you're unsure whether there's a water user's claim on your water right, call us up. We'll find out, okay? If you're unsure, file a claim anyways. Not going to hurt, okay? So, yes, sir?
How accurate is your website? Because I found my claim on the website.
How accurate is our website? Boy, that's a loaded question. Yeah, as good as the data that was uploaded to it. So one thing that I was going to talk a little bit later, but now is a good as any time. A lot of these water rights were filed back during World War II, in the 40s, and there weren't a lot of engineers around because they're all fighting Nazis, right? And so what the state legislature at the time did, they said, well, there's not a lot of professionals who can verify the location of these wells. We call that a proof, because when you file for a water right, you got to file a proof on it. So they wrote into law something called a no proof required. Sometimes we abbreviate that by saying NPR. And what that said is they would appropriate a small amount of water, and then the state wouldn't require a proof, which is great. The problem is that the location of those wells was never verified by a professional. And so sometimes they're off. And so when you look at our database, you have that to consider. You also have this problem with the PLS, the Public Land Survey System, may not be accurate, or the description. So there's a bunch of reasons. If you look at our website, which I'll show you everyone after how to get to this interface, it might show a well in the middle of your driveway or in your house, and you say, well, my well's out back. I don't know what the state engineer's smoking here, right? It's just because there's a lot of different issues that kind of play into where that point gets projected. So there are some points that are spot on. There are a lot of points that may not be as much. So you kind of take them with a grain of salt. Yes, sir?
So if you don't know, would you recommend having a surveyor come out and survey that location?
So this question is, if you don't know the location, would you recommend having a surveyor come out and survey that location? You're certainly welcome to, but at the end of the day, when you file a claim, we're going to come out and evaluate it, and we're going to get the correct location using a GPS. So we're going to verify it and make sure it's accurate moving forward. Yes, sir?
I noticed on the map that there are a number of wells that are, look like a development corporation. I know in that particular area that there's houses built over those. What happens to those development corporations that look like they have water rights with this adjudication process?
So the answer is we'd recommend to the court that they be disallowed. They'd be taken off the records.
But it looks like a development corporation has claimed this water, right? I'm wondering, are they leasing the water, even though that there's no offer?
So I'm not sure what you mean by development corporation, I guess. Ultimately, at the end of the day, if the water's not being used and hasn't been used for 7 years, we're going to recommend to the court that it be forfeited. There are some minor exceptions to that. Some of those exceptions include public water suppliers. They have better lobbyists than everyone else. And so they got the legislature to say, hey, they're immune from forfeiture issues because they've got to provide water for the anticipated projected growth in their own municipalities. So,
Would there be any compensation?
Zero compensation. Just the pleasure of dealing with the Division of Water Rights. So that's your compensation. No, there's no compensation because it's just the water right has ceased to exist. So it's not really a taking. It's forfeited by default because it has no longer been used. Okay? I know that sounds, again, one of the more controversial aspects. Totally understand, empathize with that. But John, do you have a question?
Yes. Just a couple of different twists on the question that was just asked. That here in the Lehi area, over time, there were a lot of wells that were flowing wells that served homes, and that as the area developed, more groundwater was pumped. As the gentleman pointed out, water levels dropped, so the wells were no longer sufficient to serve homes, and many of these people connected to the city system. So when you go out and you review these claims, who are you going to give the water right to? The city, who's now serving water to the property, or the property owner who has a well and some evidence of a past water use?
So there's a couple, so just for benefit of everyone, his question is in Lehi, and this is common throughout Salt Lake Valley, homes were built, wells were drilled to satisfy the domestic needs of those houses, those homes. Eventually, the infrastructure from a municipality came out and connected those homes to their residential supply of water, and the well was severed from the house being used and is subsequently fallen out of use. And not to mention the fact that the groundwater has dropped, and they were once artesian flowing wells, they're no longer, and so they just haven't been used. Is that the scenario, John? Does that paint it pretty close? All right. So who does the division give those water rights to? Well, my first gut instinct is, well, if the water hasn't been used for 7 years or more, it would be considered disallowed. It would be forfeited. If the well is still being used to irrigate the property, then it's going to go to whoever is the owner of record until someone updates title and changes the ownership. Okay? Does that answer the question?
Just in the course of the division coming out and verifying the uses of water to location, are they going to measure the flow of water then and to document the uses of water that are currently being made from the well?
So the question is, will the division, in Salt Lake City, they have a number of houses, again, severed from their domestic culinary connection, but what we would do to verify use. We don't worry as much about the flow rates, simply because usually what we end up doing is if a well had the flow rate measured. I'm going to answer 2 more questions, and I'm going to go to the next slide, all right? Yes, sir. So it's a great question. His question is, if you have a water right, a well permit is the term he used, but it's really a water right, do you have to refile? The answer is yes, and that's going to get to my next point here shortly, as to what the repercussions are if you fail to participate in this process. Now, if you've already filed a water user's claim, which is a little bit different, the answer is no. But if you just have an application, you filed proof on it, and this is the first time you've ever received notice to file a claim, then you will need to file a claim. Otherwise, there's some pretty severe consequences as a result of that. All right, one more question, and I'm going to continue off the slide. Sir?
Are you aware of what happened in Benjamin a couple of years ago?
Am I aware of what happened in Benjamin a couple of years ago? I am not. All right, let's carry on. All right. So if you have one of those water rights of record that you fail to file a claim on, all right, so let's say you have a well in your backyard, you filed a proof on it, and it's been certificated. If you fail to file a claim, it goes on this list of unclaimed rights, okay? And that list gets sent to everyone so they can look at it, and it gets filed with the court, and if people can object to it, and ultimately what happens is if you fail to step forward and say, no, I have a claim, here's my claim, the court can decree your right as being abandoned, right? So if you don't participate, that's one of the consequences. So we encourage people to participate. It's not hard, I promise you. We will help you file your claim. And it's free. You call us up. It's not that big a deal. All we need is your John Hancock on it, all right? Again, I'm going to get in a little bit more detail on that. We'll have a public meeting once that list of unclaimed rights comes out, similar to this. I don't think we'll do it in this elementary school. We'll probably find a better venue. And then we'll have objection resolution. All right, the last final tier of this process is the claim investigation. So if you file a claim, one member of my staff will come out and evaluate that claim. So if you feel like, if you file a bad claim, if you're just claiming, oh, I have a well, but it's, cannot be seen use consistent with how it was appropriated, that's what it's going to look like. That's what it's going to be recommended to the court. If there's been some partial forfeiture or whatever, then we might shave off whatever use you haven't been using and narrow down the scope of the right down to that use. For instance, if you had a culinary connection to non-use or partial forfeiture. Following the proposed determination, you'll have an opportunity to object or disagree with the state engineer about how we evaluated that. Again, I'll get into all of it, right? So if you file an objection, you disagree with us, we've got to somehow resolve that. And that either means that we're going to litigate it or we're going to come to some reasonable conclusions. Or maybe we just screwed up and we're happy to fix it. Notice, it'll tell you you have 90 days to file a claim. And we'll also publish this notice in the local newspapers. For those who are property owners who we don't have record of owning a water right, we will simply provide a blank water user's claim form, all right? It's just a form. You can fill it out if you feel comfortable doing that. If you don't feel comfortable, give us a call and we'll walk you through, or, come in and we'll help you fill it out, and you can file it right there at our front desk. If you are a water right owner of record, and there are it's like 1,200 water rights, to do is sign it and send it back to us, okay? Again, like this gentleman said, this happened back in the 80s. There was a lot of people out soliciting claims because at the time we were going to adjudicate this area, but then they decided, oh, this is too complicated of an area. We're just going to, the water, you're just using it in a way that's non-conforming with the water. So your question is, how long will the recertification process take? I presume you mean our evaluation and recommendation to the court. So our evaluation, we're going to get 1,200 claims that we've got to evaluate in this area, okay? Maybe less than that because some people won't file a claim. So what happens is I got a staff of 4 people working on this subdivision. And they have to go through each claim and contact the water user and go do the field evaluation. So there's no real established time frame. It's going to be a while because there's a lot of water rights of record in this area. So I don't have a good feel for it. But the next, so if notice to file a claim comes out in 2 weeks, the 90 days begins. And let's just assume no one files their claim till day 90. So that's 3 months already gone down the road. And then you got another 3 to 4 to 5 to 6 months of evaluating those claims that's going to take place. So you can kind of see how this is a pretty lengthy process. All right, let's keep on driving. So for those water rights that make it on a list of unclaimed rights because someone has failed to file a claim, you have this, you can object. So let's say you just, for some reason, dropped the ball, failed to file your claim, and you had a good reason for it. You could file an objection with the court and at the same time file your claim with that objection and then send the state engineer a copy of the claim. And we would probably say, yeah, no problem. But you have to file it with the court, and then we would say, yeah, sure, take it off the list of unclaimed rights. So those are easy. But don't get lazy, all right? Let's file the claims, because otherwise then you got to figure out how to file an objection, and if you don't want to figure that out, you got to hire an attorney to do it, because that has to go through the court, all right? So we are obligated to resolve all of those objections, and those are pretty easy objections. We just say, sure, we have no problem with people filing claims. We understand sometimes mistakes happen, you drop the ball, whatever, playing Xbox all day, I don't know. Those types of things happen. So you fail to file a claim, and we can choose to litigate it, but we typically just allow it, okay? Well, once we resolve all those objections, we'll petition the court to issue a decree on the list of unclaimed rights. And at that time, the court will say, all right, these claims, these rights that remain on this list, they just become invalid, okay? They become abandoned. So that's why you want to make sure you file a claim. Let's talk about the proposed determination. So you remember us, we're going to come out, we're going to evaluate your water right, and then we're going to make a recommendation to the court called a state engineer's recommendation. And we get all these state engineer recommendations and we compile them into one big book called a proposed determination. And really what that is just the state engineer's recommendation to the court as to how the water rights should be administered. So we'll file it with the court, we'll send notice, but this notice only gets sent to people who actually filed a claim, okay? So if you didn't file a claim, you will not receive notice of this proposed determination. Now, you can always call up and say, hey, I want to be put on the list to receive notice, and we'll make sure you get on the list and make sure you get notice of that. We hold another public meeting. Again, it's attended like by 5 people or so. We're forced to resolve the objections before the court can issue a decree, and we'll either litigate those. These are a little bit more contentious sometimes. If the state engineer, if we believe that no, we made the right recommendation, and the water user says no, you made the wrong recommendation, we may end up litigating it and going to court and having oral arguments and all of the depositions and all the fun stuff. But we typically try to negotiate a settlement. And quite frankly, if we're wrong, we will make the correction without issue, right? If we did some type of clerical error, or maybe we just didn't see something, we're pretty easygoing. Like we have no dogs in the fight to reduce anyone's water right or to get a water right wrong. We want to make sure it's accurate. We want to make sure water users ultimately are using their waters based on their rights. Once all those objections are resolved, the court will issue a decree, and that's kind of like the gold-plated stamp for how a water right should be, right? You can have a certificated water right, which is pretty good, but a decreed water right, that's where you want to be. And so that's the ultimate end objective of this, is to get a decreed water right out of this process. If you have a decreed water right, it gets double decreed. So typically, the decreed water rights we deal with are from these court actions involving limited parties. And so it might be decreed, but it's only decreed against those other parties. It's not really decreed against everyone else. And so this brings everyone else, and now that decree is good as against everyone in Utah. Okay, so it's actually a little bit better decree. Yes, sir. Yeah, thanks. So yeah, you still will need to file a claim, even though you have a decreed right. I appreciate that clarification.
So when this adjudication process is complete, are we set and golden? Will we not have to go through this?
It's a great question. His question is, hey, once you guys are done here, he's going to leave us alone for the rest of our lives, not hassle us, not come back through here again, not submit claims. Shouldn't have to, right? It should be good to go. Does that mean you can stop using your water, all the oxen free? No, because your neighbors can still rat you out and sue you and say you've forfeited your rights. So, but as far as the state engineer's office is concerned, there's no plans to re-adjudicate, because one thing the court hates to do is re-adjudicate stuff, right? They say that decision's already been made, we're not going to touch it. So we kind of view re-adjudicating areas as kind of another bite at the apple, and so I don't expect. Our goal is to move on to other parts of the states because we got plenty of other work to do beyond this. So I don't anticipate. Now, you'll still have to deal with the division of water rights for well drilling and all this other stuff that you're already doing. So. Sir?
So 1,200 water rights, 90 days, 4 people answering the phone. Is this going to be a case where I got to call in 3 or 4 or 500 times to maybe get through?
So his question is, how good are you guys at your jobs? Am I going to have to call a million times in order to get any response out of it? I'll be honest with you, you call, you might not get an immediate answer, but we'll call you back within a day or two. That's just what we do. We have a roster, we're very good. And I have more than 4 people that answer phone calls. It's just 4 people are assigned to this subdivision. If you have a problem, you have my email address, shoot me a message, say, just no one's getting back to me, and I'll make sure it happens, okay? I assure you that this isn't, we are working hard, and we'll get back to you, even if it's just a touch base, let you know, hey, we got your claim, you're looking good, we'll get to you in the next month or 2 to evaluate it, okay? I promise you a response. Sir?
What if I sell my property and the person sells it and continue using it for the same purpose that I was using it for? Do I have to sign over the water rights to that person?
Yeah, so that's a good question. And we haven't really talked about title ownership. Let's talk a little bit about ownership of water rights and how they work with land, okay? So in Utah, water rights are assumed to convey with the land that they're associated with, unless they're explicitly withheld by a deed, all right? So if you have a well on your property and it has a water right, and you sell that property, that water right goes with the property, unless you explicitly withheld it in the deed, in the conveyance document, okay? So the second part of your question is, well, can that person just continue to use it? Yeah, the person can continue, the new owner of the property can continue to use the right, nothing's changed, but we ask that, we encourage people to update their ownership with our records. It's called a report of conveyance, is a way to update our records, because although the ownership of the water right has conveyed through the deed at the county, our records don't link up with the county recorder's office, okay? And so there's another step to make sure our records represent what the ownership of the water right really is. And why do you want to do that? Well, if you ever need to renovate the well, or if you need to drill another well, or do any kind of maintenance on the well, you have to be the water right owner of record in order to get a permit to do that. Okay? So it's important that you have the ownership updated with our office to facilitate that. I'm going to drive on. Okay. Here's the boundary. You saw a map like this on the notice that you received. More dense areas that we've actually taken on, okay? We have actually printed out aerial imagery, I believe it's outside in the hallway, with this that actually has the water right numbers associated with it, so you can find your house and see if there's a well or a water right associated with that. And I'd recommend, and then I will also show you how to access our online database where you can zoom in and out of aerial imagery and identify that as well. Once this meeting's over and people who want to stay can stay. So total number of water rights on record, 1,260. Most of them are wells. We sent notice to 7,400 and change people about this process. Generally, that creates about 200 people come into this meeting. We had a little bit more. We had 200 seats set up, and I think we had a few people standing. So, issues and anticipated timeline. We're almost done here. First of all, out-of-date title. I already talked that. Make sure if you receive a claim for a water right mailed to your address and it's not addressed to you, but you go ahead and commit a federal crime and open the mail that's not addressed to you and it has someone else's name on it, we won't care. But that means that the water right probably is in the name of someone else and you probably need to update title to that water right. Again, I'll show you how to see what name is on our records here in a little bit. So you'll want to do that. It's not imperative that you do that during this process. It's just a recommendation. You can claim a water right whether your name's on it or not, and we will evaluate it. Location of no proofs required. I already kind of talked about that. Remember, all the engineers were fighting Nazis in Germany. There is no way to prove where these points of diversion were. We have a lot of those in this area. So take the location of these wells or these points of diversion with a big grain of salt because they're probably off, okay? Anticipated timeline. Here we are, January 25th. That's when we're going to send the notice to file claims. So that will start your 90-day time ticker, okay? April 25th is 90 days from January 25th, and that would be when that 90-day claim filing period expires. In July, that's typically enough time that we'll have, we've had all the people file their claims. We've had some time for some dust to settle, for some objections on the list of unclaimed rights. Some dust to settle. We'll publish the list of unclaimed rights probably July-ish, okay? Those are kind of moving targets a little bit depending on how many claims we get and some other issues. In October, if we publish the list of unclaimed rights in July, October is when that 90-day objection period to the list of unclaimed rights will expire. And then hopefully by March of 2020, we will publish the proposed determination. And you ask, well, why does it take so doggone long? We're talking about March of 2020. There are a lot of water rights to evaluate. There are a lot of complex water rights in this area specifically. And we have water rights that are diverted out of the mouth of the Jordan River right off of Utah Lake that satisfy uses in Salt Lake Valley for big irrigation companies. And we've got to evaluate those as well as as we do just the single wells in the backyards, okay? June 2020, assuming that we publish the proposed determination in March of 2020, June is when that objection period would expire. Okay, so will I lose our water right? I've kind of covered this a little bit. If you're currently using your water right in conformance with the records on the division water rights, you have really nothing to fear so long as you file a claim. Individuals using water without a water right of record, meaning you have one of these pre-statutory rights, you have a well that was drilled prior to 1935, or you have a surface right that's been used prior to 1903 and it's not on our record, you've got to file a claim, otherwise you will be barred from filing that claim in the future. You will not be able to file a diligence claim after this process in this area. So that's why this is important to pay attention. If the water use authorized under the right has fallen out of use for 7 years or more, the entire water right or a portion of it may be subject to forfeiture by the court based on our recommendation to the court, okay? Who can I contact? That's me at the top. My deputy, he is not here tonight, Gary Brimley. And then Ashley Ostraff is really going to be the team leader for this subdivision. She's going to be the boots on the ground directing the field work, all right? So if you have a question about a specific water right, that's who you want to reach out to because she's going to be able to answer your questions or find a member of her team who is working on your water right to answer that, okay? All right, I'm going to go to my phone here and see if I got anyone online that managed to shoot off water rights that show as warning they have not been verified by the state. Are they going to be included in this process and subsequently verified? Yeah, so his question has to do with, on our website, there are occasionally banners, big red banners across the water right that says this water right has not been established in conformance with Utah state law. What that means is those are water rights that were asserted via a water user's claim. I mean, we call them pending adjudication. So not only will the beneficial use be evaluated, but the pre-statutory basis of the water right will be evaluated. So if you have a claim to water, believable part that it's more likely than not that that was actually true, because I know this is hard to believe, but there's people out there who simply claim a pre-statutory right who started diverting water like in the 60s. And so we do some effort, we take some effort to verify the pre-statutory basis of some of those claims. Yes, ma'am.
The form that you will send
it out and make the revisions. It's really your claim. We just generate the data for your convenience, and you can revise it in any way you deem fit, and for each water right. But if you want an extension, you only have to file one extension, and that'll be for all of the water rights. Okay? Yes, sir.
So to be sure,
if we want to be sure, do we just file claims on all our water rights? The answer is that's what I would do. Can't hurt. And the second question is, we actually have property in American Fork, but we received notice. I presume you received notice because you're part of this was this Lehi Spring Creek decree rights. Okay. So if those points of diversion fall within this area, which sounds like they do, and that's how you receive notice, then those rights will be evaluated in this adjudication, even though it may be going elsewhere. And if it's not, we'll pick it up the next book over because we'll have one to the east of us here in a little bit. Any other questions? Or do you want me to kind of get to the online? John?
In regard to claims that have been filed, are those claims that were filed in the 60s also going to be considered as valid without filing new claims?
Yeah, so his question has to do with what variety or what era of claims will be considered as valid. So in some cases, the division sent out notices back in the 60s and say, hey, if they filed a claim, even if it's 50 years ago, that's still a water user's claim. We've got to treat it as though it were filed contemporaneously. Hold on a second. That reflects, they would have to modify it from that if they wanted to. So John's question has to do with non-use applications. So let's say someone filed a claim a long time ago, and then they filed what's called a non-use application. Really what that does is say, I'm not going to use the water for the period of the non-use. You can't use that against me for forfeiture reasons. And his question is, how are you going to evaluate that? My answer would be, well, if the period of non-use is covered by non-use applications, then we are statutorily prohibited from using that as a means to determine forfeiture, right? I mean, was there a follow-on question? I know you know the answer to that. Ahead of the non-use. So his question goes on to how far back. So let's say the non-use was filed in 1999. Are we going to go back and look before that to see if there was potential forfeiture issues? The problem is that the 15-year Lazarus clause plays into that. So we can only look back so far, but we can look back 15 years prior to the first instance of a non-use application, right? So the question may need to be ferreted out based on a specific scenario, but the answer is non-use doesn't guarantee that you won't be subject to forfeiture evaluation, but it depends on how long the non-use has been filed, and does it take us back far enough that we can't look any further, because we're statutorily prohibited from asserting forfeiture more than 15 years from the date of the proposed determination, right? Yes, sir.
I'd like you to be more specific about a question that was asked earlier.
Okay.
Rule on how much the water we can actually sell. Can that sale go through on its own merits, the process that it's currently under, or do we have to wait another 7 months and go through this stuff too?
So his question has to do with a specific scenario wherein this gentleman has a water right. He's trying to sell it. Part of that sell sounds like a change application is associated with it, and that change application is being evaluated by the state engineer to determine how much water can really be moved, right? And his question is, hey, can we do this process in parallel? Can this sale continue to move on as we adjudicate, or do I have to wait till this adjudication is over with? The answer is it can move on in parallel. Just make sure you file your claim for the entire basis of the water right, and it has an approved change application on it. It hasn't been approved yet, is what you're saying, though. It's been filed.
You've been waiting on the state for about 5 months now.
Yeah, and so you may be ripe. I'm not sure. I'm not familiar with your specific water right as to when it will be evaluated for on the change application side of the equation. But file your claim. We'll come out and evaluate it. And if there are forfeiture issues, we'll probably make a recommendation to trim the water right down. Okay, so we may just need to look at your specific. Okay, but the bottom line is, in broad strokes, is these other processes, whether you're selling or buying, can continue unimpeded through the adjudication process. There may be second and third order spillover effects onto what your water right is worth as a result of the adjudication, but there's nothing that says stop the change application process as beneficial use, and sometimes those are.
The sale could go ahead and be approved prior to this adjudication process being completed.
Yes, so his question is it possible that the sale could go ahead and be approved before the adjudication process is completed? Yeah, it could. And the buyer, which I presume is a municipality you're selling to and trying to change it to municipal use, right? And the buyer may say, well, time out until this adjudication gets over with. We want to see what's on the other end of this before. So the sale has nothing to do with us other than the change application process, but it's going to be buyer-seller relationship. And so there may be, like I said, some second and third order effects that kind of play into that sale, but I don't know for sure. And,
Why would the state?
Adjudication process, because the change application process is not allowed to assert forfeiture. The adjudication process is. So the change application process can't say you have 100 acres, but you've only been using 25 acres, so your right's only 25 acres. All they can do is approve the change for 25 acres, and you still have this remaining 75 acres. The adjudication come in and say, you only got a right for 25 acres because that's all you've been using. So there's some different differences between the appropriation side and the adjudication side. Let's talk afterwards if you have more questions. Yes, sir.
Just to clarify something.
Okay, so not necessarily, because it's if you're not using the well, or if the well, because really that water right is still only approved for that well and for the beneficial uses associated with that property. So what's going to happen is whoever owns that property is probably going to use the water right that you own, and until you move, you may say file a change on it and move the water out of that well to another location, at that point you'd be responsible for capping and abandoning that well. So it doesn't necessarily automatically mean it has to be a capped and abandoned, but that's typically the trajectory that it's on. All right, are we ready to do some show and tell, dog and pony show on the water rights database? All right. Let me fire up my hotspot here. Thanks, Paul. Okay, let me actually get to our... Good enough. All right. So this is our homepage, www.waterrights.utah.gov. Let's say you want to look and see if you have a water right associated with your home or your parcel. How would you do that? And I'm going to say the easiest way to go is to go over to this little icon right here that says Map Search, okay? That's how I'm going to do it. Select that link, and we'll see how fast this populates. Not too bad. And it's going to bring up the entire state of Utah. Just to increase the speed of how I navigate, I'm going to deselect points of diversion. I'll reselect it here in a little bit, but first of all, I want to show you some other features. So you see that blue dot? That means it's geolocated to where our physical location is. It's just a feature. Sometimes it may have that, may not have it, okay? But I'm going to just kind of zoom in here. And forgive me, this mouse pad is just kind of not super easy to navigate here. So let's zoom into Lehi. First thing I want to show you is over here in this column, you see the label that says Adjudication Books. I'm going to select that first. And what that will do is that will show you all these subdivisions that I've talked about. You know how we talked about elephants taking one bite out of the elephant at a time. That's how we're going to eat it. Well, you can see the subdivision here. This is Area 55, Book 4. So that's this subdivision right here that we're talking about tonight, all right? So there's a couple ways you can find out. If you're really good at maps and orienting yourself to the map and you feel comfortable in zooming into your house, we can do it that way. So I'm just going to zoom in. Zoom in here, and then I'm going to select points of diversion, okay? And you can see all these red icons. Each of those icons represents a water right of record. Red indicates a well. There's a little well icon on the button. And each icon has a water right number associated with it. You can see these have a 55-some number, okay? And so let's say you're living in this house right now. Let's not do that one. Let's go somewhere else. Let's find a different place. All right, let's say this house. You're living in this house, and you've always wondered what that strange pipe was sticking out of the back corner of your property. And you come here and you say, hey, it looks like there's a well in my yard. Or maybe you already knew about it and you've been using it. You can select the icon. And it'll pick up a summer claim. This was a well drilled prior to 1935, and then people subsequent to that filed a claim on it, all right? An underground water claim, not a water user's claim. You can take you to our water rights database that will provide a great deal more detail on this water right. the address with 55.4. And you scroll down, it'll show you the point of diversion. That's the PLS description. When we talk about where the location of the point of diversion is, this is what a PLS description looks like. In essence, that means north 287 feet, east 556 feet from the south quarter corner of Section 17, Township 5 South, Range 1 East, Salt Lake Basin Meridian. Below that, under water uses, you can see what this water right was authorized for. In this case, it was authorized for the irrigation of 4 acres, right here, 4 acres, 3 ELUs. ELU is a term, is an acronym for equivalent livestock unit. Just think of a horse or a cow. That's what it is. So if you had chickens, if you had a bunch of chickens, that might add up to 1 ELU. And so this is how we quantify stock watering. And then it had a domestic use. And down here is actually authorized for 5 EDUs, or equivalent domestic units. So 5 houses is what this water right was originally authorized beneficial use for, all right? And then down here, this just shows you where the place of use is located. These little tick marks, this is the corresponding section, township, and range. And then this tells you which quarter the place of use is located. And same thing with the place of use stock. Okay, so that's kind of the down and dirty, how to get to where you need to go. Now, there are some people who may not be as good at finding locations on aerial imagery and trying to figure out. So you can also do a search over here. So if you go up to this tab and you go over search, you can do this drop-down menu and select address, okay? Or if you know your county parcel number, that's another way. But we're just going to do address just for fun, all right? Someone give me their address. 31 search. And it'll give you a red X as to where they think your property is located. Did I do that right? 3154 West Main Street. Okay, we're at the right spot. So you can see this open pasture, has a bunch of wells associated with it. And some of the layers you can even click on is for instance, you can do parcels down here, and it'll show you where the parcel lines are. And this is based, you have to give, these are grain of salt, right? These are not surveyed property lines, but it kind of give you an idea of where the property lines may be for the parcels, okay? So that's another way, and you can access those water rights just as you would anywhere. This looks like a municipal water right to me. Just, let's see, City of Saratoga Springs, how'd I know? And the reason I know is because there's a bunch of water rights piled up on top of each other, and there's a small little parcel here, and that's typically indicative of a municipal well. They will buy a parcel, sink a well right there, right? And then change a lot of water rights to be used out of that single well. Which brings us to another good point is you can have multiple water rights out of one well, as evidenced here. Okay. Did you have a question, sir?
Do one more.
Okay.
E700 south.
Let me just unselect this. Sorry, say it again.
250 east, 700 south.
There you go. You got, it's like 2 water rights stacked on top of each other, maybe. Yeah, and those are the water right numbers. That's all I see of record. So I caveat that's this water rights of record that I see. We can zoom out and see if there's more. I mean, there's some over here as well. Documents tab. This will show you all the documents we have on our files in the state engineer's office. Okay? So you can sort these, but if you just click on it, see, in this case, this water right that we selected actually had a water user's claim filed on it back in the 89. So if you wanted to know if your water right had a claim filed on it, you could do that, okay? And you can select the water user's claim, and it will come up with the scanned image of the document that we have on our file. Just be wary or be apprised that, the scanned documents folder isn't always 100% accurate. So make sure, it's always better to verify that this is the case, all right? You always come into our office and say, I'd like to see the water rights file, the hard copy, and we'll bring it out and sit with you and look through it, okay? Because that's the official record, is not the scanned documents, but the actual jacket file at the office. What other questions you got for me? Yes, sir.
When I received the notification for this meeting, documentation of the witness, as I said before, I did this in 1988, but I received not only 2 letters, one for each well in my name, I also received it for the guy who drilled the wells back in the 1900s. He died in 1943.
So that's probably because he is listed as the current owner of record for those water rights. You filed a claim, but that claim does not update title. So here's the problem. You could have, anyone can file a claim on any other water right, and so we don't say that that automatically updates our title records. You have to have this report of conveyance done by a professional who can trace the conveyance of the gentleman who filed the claim, or who drilled the well, and show how he conveyed that property down the records until it lands in your name, and that's how we trace the lineage of the water right and update title. We don't just take a claim. Claim won't update title, and that's probably why you received those 2 notices. There's, let me show you. On our website, it will explain of the county, and then they take back, they to where the title of the property was common with the title of the water right owner of record. And then they file that report of conveyance with us for a nominal fee. Don't have a good idea what that fee is, but there's contact information, and you can read up here, but that's the process of getting it updated. You betcha. Good question. Yes, sir. Notices. The only thing I can think of is either the address is still in the owner of record for the original water right, hasn't been updated with us, and still has a bad address. We may have, here's what we did, was if there were duplicate addresses, we tried to pare down, and sometimes we miss that. But between property owners and water right owners, we'll
Clarify, when you say that we have to refile, that is done when we receive the letter that you will send out on the 25th, signing that and sending it back in is refiling. Is that correct?
Yes, that's filing a claim, correct. Yeah, and that's what you want to do. Again, you can look at your water right and see if there's already been a claim filed on it. But just be careful, because a claim is not the same thing as an underground water. A water user's claim is not the same thing as an underground water claim or an application to appropriate or a diligence claim. Okay, it's a very specific legal instrument. So I just caution people, if you have any questions, say, just call us up, and we'll be able to say, yeah, there's already one on here. You need not file a claim. We would like it if you did, but if there's no changes, you don't have to. But we're going to come, at the end of the day, if there's a claim filed, we will come out and evaluate it and look at it. But, yes, ma'am.
There's more than one owner on water right, does each owner?
That's a great question. So her question is, if there's more than one owner on a water right, do each owner have to file a claim? So the answer is they probably should, but we interpret the statute liberally to say, that in theory, claims are personal, meaning it's your claim. And if you fail to file a claim, that person is barred. We haven't, for claims where you have multiple owners on the water right, we haven't really been sticklers about that. We say they filed a claim, they've preserved off the list of unclaimed rights. We're not going to drop people off of the ownership as long as someone files a claim who is an owner on it. So, but they'll each receive a notice to file claims, each of those owners on the water right. Yeah.
So if someone filed a claim in 1999 and it was only filed for part of the beneficial use that was on the original claim, but there were multiple owners at the time. We had a situation But don't they have some right to say there were multiple people that
Yeah, that's a problem I've seen before. Let me give you my take on it, and I'll tell you now, policy has changed. So a water user's claim is a legal pleading in court, and just like any other claim, the claimant should have the right to amend their claim, right? So we take that and we say, hey, they may have filed this water user's claim, and let's say that the water right, the base right was for 100 acres, and back in the 80s, they filed a claim and only showed 20 acres. Historically, the state engineer has kind of taken a hard line and said, nope, your right is now only for 20 acres because that's all you claimed. I've managed to soften the current state engineer and say, well, that's a claim, but they can always amend their claim. And so our approach is if you file an amended claim, file a new claim, and you file for the whole thing, we're just going to come out and we're going to evaluate what's there. So we're going to give the benefit of the doubt as much as we can to the water users filing the claim. But yeah, you're right. In the past, there has been kind of a hard line associated with some of those previously filed claims. But talked to Kent Jones, who is the state engineer, and I think he's kind of gone this other direction. He's comfortable with that. And that's how we've approached others. Okay. Any other questions? Any concerns other than how to navigate this thing, right? Hey, if you have any issues, just give us a call. Honestly, we've heard everything, and we're here to help you navigate this process. I know it's not very comforting, but we try to make it easy. So thank you for your time. If you have specific questions, come on up, and I'll answer them. I have some staff back there that can also answer questions. This is the summons. So this is the legal requirement. We say, hey, you're joining. And then this is an order from the court that allows us to send this summons by regular mail. It's confusing. Yeah, let's take a look.